Good morning, one and all present over here. My my name is Rahul Sani, and my topic for debate is Uniform Civil Code. What is Uniform Civil Code? The term Uniform Civil Code is expressly mentioned in Part 4, Article 44 of the Indian Constitution. Article 44 says the state shall endeavor to secure for all citizens a uniform civil code throughout the territory of India. Uniform Civil Code means all sections of the society, irrespective of their religion, caste, shall be treated equally according to National Civil Code, which shall be applicable uniformly to all the people uniformly. They cover areas like marriages, divorce, maintenance, inheritance, adoption, and succession of the property. It is based on the premise that there is no connection between religion and law in modern civilization. And what is Article 44? Article 44 corresponds with directive principle of state policies, stating that state shall endeavor to provide for its citizen a uniform civil code, that is UCC, throughout the territory of India. Historical perspective of Uniform Civil Code, pre-independence or colonial area. The Lexis Colony Report of October 1840 is suppressed the importance and necessity of uniform in the codification of the Indian law relates to crime, evidences, and contract. But it also recommends that personal law of India and Hindus and Muslims should be kept outside such codification. The Queen of 1859 proclamation it promised absolutely not interference in the religious matters. So while the criminal laws were codified and become common for whole country, the personal law continued to be governed by separate code for different communities. Secondly, after post-colonial era, that is 1947 to 1985, during the draftation of the constitution, prominently leaders like Jawaharlal Nehru and Dr. B.R. Ambedkar pushed for a uniform civil code. However, they included the UCC, that is Uniform Civil Code, in the directive principle of the state policies, that is under Article 44, mainly due to oppression from religious fundamentals and a lack of awareness among the masses during that time. Some of the reform of this period were like the Hindu Code Bill. The bill was drafted by Dr. B.R. Ambedkar to reform Hindu law, which legalized divorce, opposed polygamy, gave right of inheritance to the daughters, admit inheritance opposition of the code, and diluted version was passed via 4 different laws. And secondly, succession. The Succession Act of 1956 originally did not give daughter inheritance rights in the ancestral property. They were lacking in that aspect. They could only ask for right of sustenance of joint family property, but this disparity was removed by an amendment to an act on September 9, 2005. Also, if we discuss about a case of Shah Banu case, 1985, a 73-year-old woman, Shah Banu, was divorced by her husband using triple talaq, saying, I divorced 3 times, talaq, 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 and was denied of maintenance. She approached the court, and the district court and the high court ruled in her favor. This led to her husband appealing to Supreme Court, saying that he had fulfilled all his obligation under Islamic law. The Supreme Court finally ruled in her favor in 1985 under maintenance of wives, children, and parents provision under Section 125 of IPC, that is Indian Penal Code, which applied to all citizens irrespective of their religion. Further, it recommended that a uniform civil code be set up. Facts of the case briefly can be explained. That is, under Muslim personal law, maintenance were to be paid only till the period of iddat, that is 3 lunar months, regularly 90 days. And secondly, Section 125 of IPC, CRPC, that applies to all the citizens provided for maintenance of the wife. In fact, after the historic decision nationwide, discussion, meeting, and allegations were made. Then government under pressure passed the Muslim Women Right to Protect on Divorce Act, MWA, in 1986, which made 125 CRPC inapplicable